This is part 14 of my journey through the court system in the state of Connecticut. At the end of part 13, I was talking about how on March 31st, 2022, a girl named Elizabeth Protzman, who also goes by the name of Libby Protzman from Marlborough, Connecticut, who I tried to be friends with, had filed a restraining order application against me in the Hartford Superior Court, which on the same day that she filed it was denied. The court denied her application for a restraining order on March 31st, and they scheduled a hearing to be on April 8th, 2022. Everything that she wrote in the restraining order application, as well as everything that she reported to DCF, were allegations that were perjury, frivolous, and made with the intent to harass me. This is all happening about 1 month after I found out that I got accepted into the University of Connecticut School of Law and that I was going to be starting law school that fall. You can see here that the court entered in this order that we were going to have a hearing April 8th, 2022 at 2 p.m. in Hartford. Here's the docket number. This is the case that she filed against me on March 31st, 2022. Denied ex parte and scheduled for this hearing date. So then on April 5th, 2022, I filed this case flow request in the case where she had filed the restraining order against me. I said, I'm requesting that I be able to take part in the hearing via phone. I said on April 5th, 2022, I was granted a civil restraining order against her. I was not properly served at least 5 days prior to the event with her order for the hearing. I have another prior custody matter scheduled already for that date. For my safety, I want to appear via phone, and I have a restraining order against her. I also filed on the same day this motion for continuance, saying I was not properly served at least 5 days prior to the hearing. I need more time. I was also granted a civil restraining order on the plaintiff today that states no contact and for her to stay away from me. And I was asking that they continue it to 4/26/22. So on April 5th, 2022, the court granted my continuance and rescheduled the hearing to be Friday, April 22nd at 11 a.m. in the Hartford Superior Court in Hartford, Connecticut. This was the new order for notice of court hearing that they set out, rescheduling it for April 22nd, 2022. So on that day of April 5th, 2022, I went to the Milford Superior Court in Milford, Connecticut, and I filed this restraining order application against Elizabeth Protzman. I said, I first met the respondent in February 2019 when I was pregnant with my second child. She donated some baby items to me, which I picked up from her home. Then, from 2019 to 2022, I remained friends via Facebook only with her. We chatted from time to time and met for dinner and drinks for the first time on February 18th, 2022. Since then, we had several dinner dates and were friends. Elizabeth offered to help me pick up my child from my ex, who I have been going through a difficult custody battle with. I told her I didn't need her help. However, she insisted and claimed that she wanted to help. On March 28th, 2022, she told me via text message that she would help by writing a character letter for me, and at 10 a.m. that day, she offered again to pick up my daughter, stating she would have her son with her. She said she would have her weapon with her as well. She stated that, quote, nobody is coming near you or me, end quote, and, quote, so if they try anything, I'll bring my weapon, end quote. I asked her to reach out to my daughter's grandmother about meeting her, since my ex told Naugatuck Police Department that the child would be with the grandmother. Elizabeth called the grandmother, who told her not to contact her, and subsequently gave her number to my ex. My ex contacted Elizabeth and offered to meet her after confirming that the child was not at the grandmother's house. I explained to Elizabeth that I didn't feel comfortable with her communicating directly with my ex behind my back, given our pending custody battle. Elizabeth reassured me that she wouldn't contact him, and on March 29th, 2022, stated that she blocked my ex at 5:11 a.m. after sending me insulting messages he sent her. That same morning, she asked again at 6:17 a.m. if I wanted her to pick up the baby from him, offering to meet him for me. She then sent me photos of a man named Steve she had been stalking and referenced another man named Vinny who she also stalked. She then at 8:06 a.m. told me my ex contacted her again. When I questioned why she unblocked him, she became highly defensive. She ended up threatening me, saying if I contact her that she will send lies and allegations of harassment to my future school, family court, etc. She filed a false report on me to DCF and told me she will ruin my life. She has weapons. She has stated on multiple occasions that she has weapons and that she isn't afraid to use them. She knows where me and my children live. Over the last few months, she has developed an unhealthy obsession with me. She became obsessed with me and would constantly praise me on social media. She's now using DCF to harass me and has filed false statements to try to obtain a civil restraining order on me. She has been in constant communication with my ex and continues to contact my future school, colleagues of mine, family members, and friends. She told me she was going through a divorce and became enraged when I messaged her husband on Facebook on March 29th, 2022, after she had unblocked and communicated with my ex behind my back. Her husband, Christopher Smith, stated, quote, "She is delusional and creates these fantasies that I honestly think she convinces herself are true," end quote. Vinny, a man she stalked, stated, quote, "I find this scary," when I showed him proof of her stalking him. I now fear for me and my children's lives. So the same day that I filed that, on April 5th, 2022, it was granted ex parte. And the judge who granted it was in the Milford Superior Court named Erica Tyndall. So keep in mind, she tried to file one against me on March 31st, 2022 in Hartford Superior Court. It was denied ex parte and scheduled for a hearing. I filed one on her on April 5th, 2022 in Milford Superior Court. It was granted ex parte and also had a hearing scheduled. And this is a copy of the restraining order you can see here. So you can see here that this was signed on 4/5/2022 by Erica Tyndall. Here's the case number, and here's me as the protected party. You can also see here that she is the respondent. It says, "Do not assault, threaten, abuse, harass, follow, interfere with, or stalk me. Stay away from my home. Don't contact me." And it also applied to both of my kids. This order also protects the following minor children, and it says, "Stay 100 yards away from me." This was granted April 5th, 2022. They then scheduled us for a hearing for April 12th, 2022 at 9:30 a.m. in Milford. So on that same day, I filed a motion for continuance, telling them that I have a scheduled custody hearing in New Haven on the same day, which I did. On April 8th, Judge Brown granted my motion for continuance. So all of that was going on behind the scenes in the Milford court and the Hartford court, while at the same time, my custody case with Matt was in the New Haven court. And so the emergency ex parte custody order that I had filed in February was scheduled to be heard on April 8th. So this is the hearing that took place on April 8th, 2022, in front of Judge Jane Cupson Grossman in the New Haven Superior Court. This was the first time that both Matt and I actually appeared in front of her, and the first time that she got to see both of us and preside over our case. And I believe that she was extremely unprofessional, violated many of her judicial canons and our constitutional rights during this initial hearing on April 8th, 2022. So let me know what you think.
The next ready matter is Antar and Lodice. Lodice.
Good afternoon, Your Honor.
Please remain standing while the clerk swears you in.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you are about to give concerning this case is the truth, the whole truth, nothing but the truth, so help you God upon penalty of perjury? Please say I do.
I do.
I do.
And starting with you, Miss, can you please just state your name and address for the record? You guys may be seated.
Okay. All right. So this is a custody case. Actually, I think it's a visitation petition. initially it was a visitation petition, filed by you, ma'am, right?
Yes.
And what brings us here today is an emergency motion for custody. That was filed in mid-March, and I think that was also filed by you, right?
Yes.
It was denied and set down for hearing today.
Correct.
And I have a note from Family Relations indicating that you were not able to reach an agreement about what should happen with that emergency motion, and we'll need to have a hearing today. So does that sound right?
Yes.
All right. So the way we'll do that, ma'am, is that you filed this application, so you'll go first. You'll tell me what the emergency, or you filed an emergency order, so I have to consider what the emergency is. You have a bigger case going on about when you should see your child and when the child should be with you and when the child should be with the father. But today I'm just considering the emergency portion. You understand? All right, so what you should tell me is what the emergency is and what you want the court to order and why you think that's appropriate. And then, sir, you'll have an opportunity to do the same, and then we'll make some decisions just on that emergency motion. Okay?
Okay, and I just wanted to say also, when I filed the emergency motion, the clerk's office told me I had to also file a modification along with it, which I did.
Okay.
So I actually prepared something for the court, if it'd be okay if I just read it.
Look, it's generally better for me if you kind of just tell me without reading, but if it's easier for you to read, that's fine. It's just that I might interrupt with questions.
Sure, that's fine. I'm here today to ask the court to modify certain details of our custody and visitation agreement for our child, Angelina Maria Lodis. I want nothing more than what's in the best interest of our daughter. Over the last 10 months, Mr. Lodis has disrespected the court repeatedly by refusing to follow many parts of our custody and visitation agreement. In April of 2021, Mr. Lodis began begging me to take him back and told me that he would do anything that it takes to have me back. He emailed me daily, called me daily from numerous fake numbers, and promised me that he would do anything to make me happy. I repeatedly told him that I was not interested and that all I wanted was for him to co-parent with me in a healthy way so that we can work together to raise our 2-year-old daughter. Mr. Lodis continued to try to beg me to take him back, repeatedly asking me to let him move back in with me. He told me that he was making more money due to his new business that he started on April 16th, 2021, Whole House Remodeling Company, LLC. He also stated that he made over $40,000 from trading the crypto coin Dogecoin in early 2021. He said that things were looking up for him and that him leaving his job at Casanova Remodeling Company, LLC in November of 2020 was the best decision he ever made. He stated that he was making more money than he ever had in his life and that he would give me more money and help me out from time to time if we were on good terms. He said if we stopped being on good terms, that he would no longer give me any extra money or buy anything extra for Angelina and would tell me to use my child support money. He stated he wanted me to be with him before all of his riches and success came about so that we could grow together. He said he wanted someone to be with him before he became astronomically more wealthy and not after. He said he would pay all of my bills and that if he moved in with me, he would pay $50 a day to me daily on top of paying his child support. I continued to tell Mr. Lodis that all I wanted was a co-parenting relationship, and this angered him. He has been emotionally, financially, and psychologically abusive to me throughout the entire 4 years that I have known him. I spent the majority of my pregnancy alone, and he told me repeatedly that if I had the child, that it would ruin him and his other sons' lives, and that he couldn't put them through the pain of having another child take attention away from them.
Ms. Antar, I'm going to stop you. And the reason,
Okay.
listen to me. The reason I'm going to stop you is because you filed a motion telling me there was a present emergency. So what's the thing that's happening right now?
Okay, I'm getting to it. It's coming up. I thought that to make it more clear for the court because there's multiple things that were filed, and I just wanted to just kind of.
Okay, I have your file in front of me.
Okay.
Maybe I should have said that first. I'm sorry. I have your file in front of me, so I can see all of the history and the court orders and the agreements.
Okay.
But you filed an emergency motion saying something is happening right now.
Right.
And so I'm trying to figure out.
Okay, so I can skip to that part. So on March 17th, 2022, I filed an application for emergency ex parte order of custody along with a motion of modification. And I wrote, at this time, Matthew was refusing to return Angelina to me. In the motion for modification, I asked that the court order current support, increase support, find arrearage, order payment, so on and so forth. The reason why is that since the date of the last order, Mr. Lodis is making more money. He's also not following our agreement. I had originally also asked that the court order him to return the child to me since he was withholding her from me. Since then, he has returned the child to me after giving me an extremely difficult time about giving her back. And so, Mr. Lodis has also lied to the court about his address. His current address is 23 Lyman Street, New Britain, Connecticut. He has lived there since January 1st of 2022. He continues to lie to the court and continues to tell them that he lives with his mother at 48 Quarry Hill Road in Waterbury, Connecticut. Mr. Lodis is renting this apartment from Gregory Gallo, who is related to his sister-in-law, Jennifer Gallo. Mr. Lodis also did renovations on the same property, which is a rental investment property owned by Mr. Gallo. He has regularly stated that he plans to tell the court that he has no income and no money, and claims that this is the reason why he has not paid a single dollar of his court-ordered child support since November 20th, 2021. He has not paid a single dollar toward court-ordered child care payments either since January 15th, 2022. I have sent him certified letters documenting all child care payments that I have been paying to our private babysitter who watches our daughter regularly. Matthew has refused to pay his 50% portion, forcing me to incur 100% of all financial responsibility for our daughter and forcing me to pay 100% of the child care costs to be able to work. He has shown great disrespect to the court and has disregarded every court order that has been issued. Our latest order is from June 15, 2021, and I'm requesting to modify the following, if I may say what I'm requesting.
Okay.
Number 3 on our order states that in a case of an emergency, illness, injury, and the like, the parents shall immediately and directly contact each other via call or text message. I'm requesting that this be modified so all communication must be limited to via email only and only regarding the minor child. And in case of an emergency, parents shall immediately and directly contact each other via call or text message. I'm asking for this since Mr. Lodis has been abusive to me regularly, calls me names, and disrespects me when I attempt to speak to him via phone. He has done this in the presence of both of my children every time I try to talk on the phone. I notified him that due to this, I would only feel comfortable communicating via email and only regarding the minor child, with the exception of an emergency. I'm also requesting to modify number 10 on our order, which states that all educational decisions must be made by the parents together. As the primary residence for Angelina, she will be going to schools in my district when she turns 5. Matthew consistently tries to argue and fight with me about everything and has shown no interest in her education. I am asking that this be modified to reserve educational decisions for me, her mother. I'm also requesting to change number 11, which states that all medical decisions must be made by the parents together. I'm asking that this be modified to reserve medical decisions for me, her mother, due to the incident that recently occurred where Matthew canceled the appointment for our daughter without my consent and then refused to take her to a dentist appointment. I have made and scheduled every single medical appointment for Angelina since she was born. I have taken the time to sign her up at doctor's offices, follow up with her care, and make sure her health is my priority. Matthew has done none of the above and has shown disregard for her by canceling her appointment, which was necessary for her to attend. I am also requesting to change number 12. This number states that the father will pick up the child every Friday at 5:30 p.m. from the mother, and pickup location for the child will be at Cumberland Farms gas station located at 527 North Main Street, Naugatuck, Connecticut, and that the father shall drop off the child to the mother at 9 a.m. every Monday at the same location. When Mr. Lodis and I sat down together in June 2021 and came up with this arrangement, we chose that location because of the fact that Angelina was coming with me to work daily at my old job, which was located in Terryville, Connecticut. Every day during the week, I would commute to 269 Main Street, Terryville, Connecticut, which is where the office is located. Mr. Lodis and I chose Cumberland Farms in Naugatuck as the drop-off and pickup point due to the fact that it was in close proximity to his mother's house where he was living at the time. He also chose...
Listen to me. I want you to put that away.
Okay.
You're here on an emergency motion.
Okay.
Put that away. What's the emergency?
Well, the emergency that was that he wasn't giving me back my child, which is what I stated earlier, that she's now been returned to me. But when I filed that emergency motion, they told me I'm also filing a new modification with it, which was going to be part of this.
I'm not hearing that today.
Okay.
So emergency motions get in front of the court right away.
Okay.
So they sort of jump ahead of all the other motions. That's why today has seemed like you guys had to wait so long, because all I'm hearing today are emergency motions. Because they get sooner court dates.
Okay.
So I can hear you out about the emergency situation. If you're telling me the emergency is solved, that's fine. But I'm not going to decide the bigger motion to modify the schedule today. That's going to get treated like every other date. The court date, you have a court date for that June 14th.
April 12th is our next court date.
Yes,
which is Tuesday.
Right, April 12th.
And the reason why that this turned into like an emergency is, as I was describing, Matthew has been not like that. Like, I quit that job back in September. So since September to now, we've only met at that gas station to do the exchange of our daughter a handful of times. I think 6 times. All the other times, he has dropped her off at my mother's and picked her up from my mother's. Now, in the last few weeks, he's been getting mad. So to try to retaliate against me, he's saying, either you meet me at this gas station per the agreement, or I'm going to say that you abandoned Angelina, and I'm going to file for sole custody, and I'm going to say you abandoned her, and now I'm going to get sole custody, and you're going to pay me child support. So that's what he's been saying to me. And so when I tried to call him multiple times, as you can see in my affidavit that was attached to this emergency ex parte motion, my typed affidavit, I stated that I asked him that day to bring my child to the dentist where she had a scheduled appointment. I said, please meet me here at this time. He reached out to me, stated he was running late. I said, okay, we can try to reschedule. But then when I called the office, they said they can't reschedule it. They said, it's okay if she's late. So I reached back out to him. I said, okay, she can just come late. Just come as soon as you can. I scheduled that appointment at the same time as my other child, so both could be there. And I was expecting for him to bring me Angelina, and she was going to go home with me after that appointment. I even asked him if I could borrow his car seat, because I was planning to take her home, and I forgot my car seat. So he then called the doctor, canceled the appointment, and said he was going to reschedule it, even though we're supposed to make medical decisions together, and the plan was for him to meet me at that dentist's office so she could do her dentist appointment, which was actually going to be her first dentist appointment, and then after that she was going to go home with me, which was on a Tuesday. So then I called the police, and I said my court order states that she's supposed to be with me from Monday through Friday, and him from Friday to Monday. He's refusing to give her back to me. He said to me, if you want to get the child, get her from my house at 48 Quarry Hill Road in Waterbury. So I drove to 48 Quarry Hill Road in Waterbury. Nobody was there. I called the police. I said I wanted to have them do a wellness check because Matthew stopped responding to all of my calls or my emails. I emailed him multiple times saying, I'm here, 48 Quarry Hill, Waterbury. Nobody's there. I called the police in Waterbury. They went there. They spoke to the homeowner, who is Roy Bowers, who is Matthew's stepfather. And Roy Bowers stated to the Waterbury police that Angelina was not there, that Matthew has not lived there, and Angelina has not lived there with Matthew since December, and that Matthew lives in New Britain at the address which I stated, which is the one I said before in New Britain, 23, I don't know.
Right, so
I lost it, but either way, the police did, I'm sorry, the police.
I read your affidavit.
Yeah.
The current schedule
Yeah.
has Angelina with you Monday through Friday.
Right.
And every week?
Every week. And so it's basically like every weekend she's supposed to go with him. And so it's like, it's not like the schedule has been a problem for us. The problem is this little statement here about this gas station is the problem, because one, I no longer work there at that office. So I'm not doing that commute anymore.
I understand. Where do you live?
I live in Orange.
And where do you live, sir?
I moved to New Britain last month.
New Britain, you moved just last month?
Yes.
And
Where do
under
you
oath he said steadily lives in Waterbury. I'm sorry.
So, why is your stepfather saying you live in Newington?
No, he said New Britain.
New Britain?
Yeah.
Okay. What's the address in New Britain?
23 Lyman Street.
And where's the gas station you were exchanging the child at?
The
Naugatuck.
gas station's at 527 North Main Street, Naugatuck, CT, and it's Cumberland Farms. And that was what we picked when we discussed this in June of 2021, because it was convenient for both of us. It was relatively very close.
What are you suggesting now?
Well, I actually wrote down one of the things, like that was the one I was asking to suggest a change. I know I was putting too much background info, but I'm just saying, I'm asking that the court remove this specific pickup location from the agreement, since Matthew now lives at 23 Lyman Street, New Britain, CT, and no longer lives within minutes of the Cumberland
So
Farm.
where do you want to meet now?
I said, I'm asking them change the pickup point to Angelina's daycare. I'm in the process of signing her up for a daycare located in Thomaston, CT. I would like to make it so Matthew drops her off at her daycare in Thomaston, CT on Mondays at 9 and picks her up from there Fridays at 5:30. If she changes daycare or school, Mr. Lodis would be able to bring her to the new school or daycare. On days when there's no school, Mr. Lodis can bring child to my mother's house, and if my mother's unavailable, he can bring her to me at a police station, which is halfway point between both our addresses, which I looked at a map and said North Haven CT might be good, but honestly, I'm open to whatever. I just don't feel like it's...
Hold on, I don't
Yes.
understand. If she's with you Monday through Friday, you're suggesting he pick the child up from daycare Friday?
At 5:30. So the daycare that I'm looking at, that I'm most likely going to sign her up for, she has to be dropped off by 9, and she has to be picked up by 5:30. And on our agreement, it says he's supposed to drop her off Mondays at 9 and pick her up Fridays at 5:30. So it'd be perfect. He can drop her off even earlier if he wanted. She can go to daycare, and then this way we don't have to have the drama of arguing and seeing each other all the time like that. We can limit the communication to the email.
Stop.
Sorry. I'm sorry.
I understand what you're saying. Listen, what I also understand is that there's no emergency anymore.
Right, and I acknowledge that.
So the only thing that has my attention in terms of like, that it might be kind of an emergency, is that your pickup and drop-off location doesn't make any sense anymore. So I will talk to you about maybe organizing a new pickup and drop-off location so that you guys don't have this disconnect anymore. That is because that involves your child.
Right.
Your child should spend hours in the car driving around the state because your parents can't agree on the location. So have you discussed this new pickup and drop-off location yet?
This is the first I've heard of it, Your Honor.
He has stated to me, like, we'll handle it in court. When we go to court, we'll handle it. And it's like the court date is weeks away,
Well,
so,
the court date's now.
so now we're here.
Well, Your Honor,
Well,
she made a lot of allegations against me. I would like to at least be able to rebut some of those. I mean,
There's no
She
emergency.
doesn't care about that.
Hey, ma'am.
I'm sorry.
I mean-
I just feel like I didn't get to finish reading all the stuff I was saying about him, and he says all this
Stop.
false stuff about me.
Listen, there is no emergency. The emergency has been resolved. You two are obviously not behaving very well with each other. That will get addressed on your April court date. The only thing that I think is an issue is your pickup and drop-off location. So I'm happy to help you try and figure that out if that's the issue, because your child should not be like driving all over the place. You want to pick the child up and drop the child off at daycare, sir? Does that make sense to you?
well, when is she starting this daycare? Because Theo will say things like that, and then I'll have issues where she won't be at that. There won't be a daycare, and then I'll go there, and she'll be like, "Oh, I didn't sign her up yet. You could just keep her." Like, I have papers of her refusing Angelina 6 different times on Mondays. This is why I wanted to say mine.
Well,
So
listen, we're not talking about any of that because there is no emergency.
but there is no daycare yet neither.
Well, I
Your Honor,
understand.
may I comment on
No,
that?
no.
Oh, daycare.
No. You can stop talking, young lady. You have interrupted me like 3 times. I kick people out of my courtroom for interrupting, so I want you to stop.
I'm sorry. I just want.
Listen to me,
Sorry.
both of you. You have a very young child in common.
Mm-hmm.
She's only 2,
2.5.
2.5.
Should be 3 in May.
You two have spent so much time in court already since 2019.
Mm-hmm.
You cannot do this to your child. This is a disaster. You two have to get on the same page. So you're only here on an emergency motion, and I think everybody acknowledges that there's no longer an emergency. I agree that you need a schedule so that you both know when your child is going to be with each one of you, and I agree that you should probably change the pickup and drop-off location. The place in Naugatuck maybe is not a good idea, but if you can't have a rational discussion with me about that, then I'm going to send you out of here, deny the emergency motion, because the emergency has been resolved, and I'll see you in April. So what is it, folks? Do you want to have a rational discussion about a new pickup and drop-off, or you want to just come back in April?
Of course I do.
I would love to. And
Okay, then we're going to have a rational, guided discussion by
Okay.
me. So she's suggesting daycare. You don't trust that the daycare has started yet. What's your suggestion?
Well, the meeting place we have now is 20 minutes from her house and 30 minutes from mine. It's a halfway point. It's not a bad halfway point. And not only that, it's also on the way to the daycare.
Right. Why do you think the place place doesn't make any sense anymore if it's 20 minutes from your house and 30 minutes from here.
So for me, I used to bring Angelina with me to work every day, and I would bring her with me to my office in Terryville. Now I don't do that anymore, so I don't bring Angelina with me to work. So what I usually do is I'll bring her to my mother on Monday, and my mom usually watches her. And then, on Mondays he has her. So on Mondays he would usually bring her to my mother. So then I would just pick her up from there. So it's very convenient because then when my older daughter goes on the bus at 8, I just go right to work.
Where's your mom?
My mom's in Woodbridge. And so Matthew has been bringing Angelina to and from my mom's this whole time since September, except for a few times where he insisted we meet at the gas station because that's what the agreement said. And so
Woodbridge, New Britain to Woodbridge is kind of a long drive, but you could do all the driving one way, and you could do all the other, driving the other way.
Well, the other thing I was going to mention also is that with with my mom, he can bring her as early as 8, which will give him an earlier start on his work day versus 9.
Do you have any interest in doing that, sir?
But
Her mother actually told me that she wasn't going to be taking her anymore from me, and that's why I stopped bringing her to her mother, because her mother told me not to. I have the proof. I have the text messages of her mom saying this to me.
I'm asking you, if I ordered it, everybody's going to do it.
Yeah, but is her mom? What happens when her mom says, "I'm not taking her today"?
Well, put that aside. Is her mother's house a better location?
My mother's house?
No, hers.
Her mother's house? Not really. No. All the way to Woodbridge? No.
Okay.
Especially if she's going to be going to. Can I direct her, or can I direct you then? Can you ask her, I guess, then, is she going to be going to daycare on Mondays, or is she going to be going to her mother's on Mondays?
It sounded to me like she was going to go to this new daycare on Monday.
If that's a definite?
If the let's put it this way: if the child was going to daycare in Thomaston, would that be easier for you?
I would be willing to drive. It's a little hike, but, I mean, it's far. It's like probably 45 minutes from my house. I mean, it'd be ideal if I didn't have to go that far, but I understand it'd be easier if I dropped her off there. But then I'm driving 45 minutes out of my way to drop her off, go back to my house, and then I'm driving 45 minutes out of my way to pick her up and go back to my house at every visit.
Well, this is why I agreed to talk about this. Your child, you should make arrangements so that the child spends less time in the car, okay? Because it's not, what 2-year-old wants to be in the car? So, and if you have limited amount of free time and you want to spend it with your child, you want to spend an hour and a half of it in the car. So it would make sense for you two to find a location in the middle, or for one parent to do all the driving on one day and the other parent to do all of the driving on the other day. And maybe a work day is not a good day for that. You two really have to do a better job of compromising with each other.
Also, I have 2 other children with my ex-wife, and I have to drop them off. I'm quartered to drop them off at school on Monday morning in Southington. So I'm going in that direction. So that's why Naugatuck always worked out perfectly for us, because it was like a perfect middle ground. It was on the way to her old job, and now it's on the way to her daycare. I still
Except
feel.
that she doesn't have the child with her.
But she's still got to go there to bring her to daycare.
no, Your Honor, may I
Okay.
please?
No, we're all done.
I just want to say one
No,
thing.
we're all done. There is no emergency. The emergency motion is denied, and we will see you two in April, and that is it. And I want you to listen to what think about the lecture I gave the last family. Do you really want a stranger, another judge, making decisions about when you see your children? You two have to find a way to get on the same page here. Like, your daughter deserves that from both of you. Like, you guys are not even really listening to each other, and you can't raise a child like that. So, in terms of today, the emergency motion is denied. There's no emergency. Your motion for modification will move forward, ma'am. You have a court date for it, and we'll address those things in the regular course of business. That's it. You folks are excused. The orders for today will be that the emergency ex parte motion is denied. Once you're done with that, we'll go through the docket and see if there's